Okay, great. I was going to say we're delighted to be teaming up with Asia MENA in-house community in relation to this presentation. Although it feels a bit strange to say delighted when we're in such bad circumstances at present. So I have some mixed feelings about this presentation, but we're very glad to share with you our experience and our recent inquiries that we've been dealing with in relation to COVID-19. We've got a considerable number of live inquiries about the current situation, and they range from reviewing people's contracts to see if the force majeure provisions are sufficient.
Okay. Andrew, can I just, sorry, one second, can I just stop you?
Sure.
I think we're having some audio issues, so I'm going to turn off your webcam. I'm really sorry about that. With the webcam turned off, I think the audio is going to be much better.
Okay.
Yes, go ahead, Andrew.
Thanks, Rahul. How is this? Sounding better? Good. All right, let me start again. As I was saying, we've been dealing with considerable number of inquiries and in fact live cases right now that arise from the current COVID-19 situation. Those range from advisory, looking at people's standard terms and conditions, reviewing contracts, making sure that they are properly protected, right through to termination and wrongful termination of contracts arising from current failures in performance, both in the supply chain and the finance situation and in construction contracts. Whether or not this situation actually constitutes a force majeure event, what is certainly clear is there is serious pressure on international trade and business in and around the region. And we anticipate, no matter how short or long the lockdown period is in Hong Kong and in mainland China, that there will be a long-term effect on international trade. We thought that it would be useful to cover a number of topics this afternoon, but to focus principally on the words that are on everybody's lips, force majeure. So we'll look in some detail at force majeure, what is force majeure, and whether or not COVID-19 is in fact a force majeure event. When looking at a force majeure event and the particular circumstances, we'll also have a look and consider the limitations, or whether there are limitations on invoking force majeure. And finally, what is the effect of a force majeure event? And there are a number of different scenarios that we've considered and look at. These come from actual cases that we're dealing with, as well as some scenarios that we've thought of. In addition, there are other complications that layer on top of the simple-ish force majeure provision. And these come down to jurisdictional issues. What is the appropriate place to deal with any particular dispute or query? What is the right law to apply? When a decision is made, whether there will be any problem enforcing any particular decision. And if this situation is not, if COVID-19 is not a force majeure event, then what is it and what is its effect? And finally, before handing over to Jezamine to look at the employment issues, we'll be having a quick look at shipping and transport contracts in particular. Well, as you may have been aware from the press, a number of companies have begun to declare force majeure in response to the complications caused by COVID-19, and perhaps one of the most high profile is China National Offshore Oil Corporation, which is China's biggest buyer of LNG. who has told some suppliers directly that it's not going to be able to honor its contracts. It's issued a force majeure notice, and it covers a number of LNG purchases in February and March of this year. Alongside that, you may be aware that businesses in mainland China are able to request an excuse certificate from the China Council for the Promotion of International Trade. And these certificates are claimed to be internationally recognized by the China Council for Promotion of International Trade. The question that we want to address and we want to think about this afternoon is, will such certificates work? How will they work? And what will the consequences be of relying on such a certificate? And just to give you a little visual, this is a copy of one of the force majeure or the excuse certificates that has been produced by the CPIT. This is available on their website, and you can have a look and see what CPIT is saying. But the interesting thing to note is that there is an assertion by CPIT that this certificate will be internationally recognized. And that is an interesting position to adopt when considering force majeure questions. I'm going to hand over to Liz now, who's going to consider force majeure in a little bit of detail. Rahul, if you could enable Liz's microphone, that would be great. Thanks.
Thanks. So we're going to look very briefly at what a force majeure event is as a matter of English law and Hong Kong law. And we will also look at whether COVID-19 is a force majeure event. Force majeure has different meanings under common law and under civil law traditions. In particular, that's relevant here because we are dealing with, and you will all be dealing with, contracts that are governed by English law or Hong Kong law, or perhaps another type of law. But the events that are taking place with respect to COVID-19 that are resulting in these force majeure certificates being issued are taking place in the PRC. And Andrew will look at the tensions there between the different systems of law in a moment. But working on the assumption that we're dealing with the common law position, then the most important point to take away is that force majeure under the common law is entirely a creature of contract. So at common law, force majeure does not have a meaning beyond the meaning that the parties have given it in their contract, whatever the governing law of that contract might be. So there is no one-size-fits-all approach to what is a force majeure event as a matter of contract. It will very much depend on the wording of the clause. So if you have a force majeure clause in your contract, then if you turn to the words in the clause, some of the words that we might expect to see as defined force majeure events in standard form pro forma contracts are things like act of God, drought, natural disaster. Those things don't seem to immediately be triggered. You might equally see a clause that states that an epidemic, a pandemic, or a contagious disease is a force majeure event. These are important terms, they're important definitions, bearing in mind that the World Health Organization has classified COVID-19 as a public health emergency of international concern. So that's the present status. Is that a contagious disease? Is that an epidemic? Is that a pandemic? It's very much going to be fact specific, and it will also depend on the area in which your contract is being performed, because the effect of the COVID-19 event may be different in that particular region. The other thing to think about is if there is nothing in the force majeure clause that specifically deals with disease or viruses, infectious contagious diseases, you may still come within a secondary trigger force majeure event. So by secondary trigger, we mean something like shortage of labour or shortage of raw materials, perhaps a strike or government intervention. So we're looking not just at COVID-19 itself, but the flow-on effects and whether those might in and of themselves be force majeure events. And again, that is going to very much depend on the circumstances of your individual case, where your contract is being performed, and what the clause itself says. The third way that you might bring yourself within a force majeure clause in a contract is if there is a catch-all provision at the end of the force majeure clause. So the typical wording that we would see for something like that is any other cause or beyond the control of the parties, or we might see wording such as any like clause or any similar clause. So we would then need to look to what the other causes or trigger events in the force majeure clause were, and whether this clause, the COVID-19 event, came within the any like clause or any similar clause. The final point to bear in mind is there another way to perform the contract? So we need to, the law expects contractual parties to work together to mitigate the loss and to work with their commercial partners to see whether there is a way around the force majeure event. Looking at certainly with respect to the catch-all provision, which is the third way you might bring yourself within a force majeure clause. One of the questions that we need to ask when looking at the contract is whether the outbreak of COVID-19 is something that was unforeseeable to the parties. And certainly in the Greater China region, over the past 20 years, we've seen a number of outbreaks of different kinds of diseases that have had an effect on contracts. We've seen avian flu, we've seen swine flu, MERS, Ebola, Zika, SARS, and now COVID-19. So it's difficult to see that a virus such as this is something that is completely unforeseeable in a contractual context. And there's some Hong Kong court authority on that point. In 2003, there is a really interesting district court case that came out of SARS called Li Qingwing. And the court in that case held that and at the outbreak of SARS was not necessarily something that was unforeseeable. What happened in that case is it concerned a residential tenancy agreement, and the tenant had been living in Amoy Gardens in Block E, which you'll recall was one of the blocks, one of the residential buildings there was a very serious SARS outbreak in that building. And the tenant, there was an isolation order that meant that the tenant was not able to go inside the building, inside the premises, for a period of 10 days. And that was in the context of a 2-year fixed term lease. And the court said that that's not enough to frustrate the contract, and that that's not enough to be something that was unforeseeable, because 10 days in the context of 2 years is insufficient to mean that the contract as a whole can't be performed. Just to contrast the Hong Kong court's interpretation, if we look at what the PRC, National People's Congress Standing Committee, has said to date, they've said that COVID-19 is an unforeseeable, unavoidable, and insurmountable event. So that's quite a different perspective. And again, we might see a tension between different systems of laws and whether they see this event as foreseeable or unforeseeable. In terms of further limitations, if you are raising force majeure as an exception to performance in a contract, the first point on the slide is mitigation, and that's a really important point. So if there is a way to avoid or mitigate the effects of COVID-19 through alternative operations, then the court will expect the parties to do that. So there really is a need, it is an expectation that you'll be working with your commercial partners through this to show that you've looked at other ways of performing the contract. And the litigator's perspective would be, if you are, as you work through that process, collect evidence and keep very good records of the steps that you've taken to see whether performance is possible through other means. Because in the event of future litigation, you'll then be able to demonstrate that you did everything that you could to try and perform or try and find other ways in which you could mitigate the effect of the force majeure event. The second point on the slide really comes down to causation. So again, when we're looking at force majeure in a common law contractual context, we need to be able to demonstrate that the force majeure event or the force majeure trigger under the contract is the reason for the non-performance. So for example, if there were two potential causes, say the cost of raw materials went up as well, and that was really the true reason why the contract wasn't performed, then you wouldn't be able to rely on force majeure. The third point on the slide is notice. So everybody knows about COVID-19. Do I need to tell anyone about it? And what happens if I don't? The notice provisions in a force majeure clause are really important. Most of the standard form clauses will have quite strict requirements about notice. So it's important that they're complied with, and failing to do so could cause issues in future.
Thanks, Liz. Thanks, Liz. We've just received a really interesting question in relation to change of law clauses in contracts. And the question asks what the requirement is to claim an extension of time or additional cost invoking a change of law provision rather than a force majeure provision. Because this is quite an interesting question, we'll just take a step to the side right now and answer that. The person asking the question, of course, has gone some way to answering the question themselves by proposing that it would depend on the contract. And certainly under English and Hong Kong law, the position, the common law position is that the parties are, of course, free between themselves to decide whatever they like. So to a certain extent, or certainly when you're first looking at this question, the answer would be, let's have a look at the contract and what does the contract allow you to do or not to do. And the next question, of course, is to say which law applies to the contract. So if the contract is under a common law system, then the answer sort of lies and stands or falls by the contract. However, if it's under a civil system of law, then there may be provisions within the legal system that allows parties to step away from the contract. For example, under the French doctrine of imprévision, which means something that is not foreseen at the time when the parties entered into the contract, which changes the nature of the contract. And there is a similar position under English and Hong Kong law, a similar doctrine called frustration. And Liz will talk about frustration a little bit later. So hopefully by the end of the webinar, we will deal with this question in a little bit more detail. The next topic that we wanted to deal with is what is the effect of invoking a force majeure provision. Well, again, similar to the change of law question, the effects of a specific force majeure clause will, if it's a well-drafted clause, will be set out in the clause itself. So, for example, in some of the standard GAFTA contracts, that's Grain and Feed Trade Association contracts, there are provisions which suspend the performance of the contractual obligations until the end of the force majeure event. In fact, that is a provision that is drafted into a lot of bespoke force majeure clauses. The parties foresee a situation where a force majeure event may, for a particular amount of time, prevent the parties from performing their obligations, but those force majeure events may subside, and the parties may then be able to resume performance, and that's particularly in long-term performance contracts. However, there may be other kinds of effects. For example, in a shipbuilding contract, the effects of a force majeure event, if properly notified, may be to extend the time for performance, and that may be the same in a sale of goods contract. The delivery date may be extended by what is called a permissible delay, or something along those lines in the force majeure clause. And in some contracts, there may be a termination provision. However, the termination of a force majeure because of force majeure is not necessarily a natural conclusion, and exercising the wrong option will be quite dangerous and could give rise to quite significant consequences. Firstly, of course, it would be a breach of contract, but what kind of breach of contract and what are the extent of the damages that might be claimed? So there are two different kinds of breach of contract in these circumstances. It may be a breach which gives rise simply to a claim for damages, or it may be a repudiatory breach. A repudiatory breach is a breach that goes to the very heart or the very root of the contract, and is so severe that it would release the innocent party from their obligations under the contract. However, a breach which does not go to the root of the contract would simply give rise to a claim in damages. So, for example, if we look at a contract of affreightment, for example, that lasts for 10 or 15 years to ship, say, cement from Vietnam to China, and a shipment date cannot be met because the cement factory is no longer operational, or is operational only for is not operational for a short period of time. Is that sufficient to go to the heart of the contract? Well, in some senses, it will always depend on the fact and degree and the particular circumstances. But if you were to take a step back from such a scenario and ask in general terms, is that sufficient to go to the heart of the contract? The answer is probably no. The other question to ask is what damages could be claimed. The ordinary measure of damages under English and Hong Kong law for breach of contract are a compensation to put the innocent party in the position that they would have been had the contract been performed. Obviously, this could lead to a large number of additional claims that might not have been initially anticipated by the party that breached the contract. And so a close examination of the facts surrounding the breach of contract will be necessary in order to understand whether the damages that can be claimed are limited to the direct losses only, or whether there are consequential losses such as the breach of subsequent or additional contracts which may be associated with the main contract which has been breached can be claimed. Liz, you're going to deal now with some of that in relation to domino effect.
So there is obviously going to be a knock-on effect from the COVID-19 situation on a number of diverse sectors, probably as diverse as automotive, manufacturing, finance, technology, construction, energy, insurance, and commodities. Wuhan and Hebei province is a manufacturing hub for electronics and the automotive industry. And we're likely to see, if we haven't already seen, production bottlenecks, inventory issues down the line, and issues caused by the restricted flow of workers, raw materials, and goods into that area. So you might need to be concerned about the domino effect if you are involved in a string of sales contracts, or if you have a transaction which involves many different contracts, for instance, in the transportation or shipping and logistics industries. So what is the effect of an upstream force majeure event on a downstream contract, particularly if you're sitting in the middle of the series of contracts or the string of contracts? The answer, of course, is going to depend on whether the force majeure clauses in particular are consistent across that string of contracts. So for an example, if we have an event that shuts down one or more segments of an industry in an affected region, a party that doesn't have the same force majeure event or the same force majeure clause is going to risk absorbing a disproportionate share of the loss. So in the example that we have on the slide, we have a series of contracts from producer, midstream, another midstream contract, and then downstream. And we see two of the contracts here have force majeure clauses that are triggered by the COVID-19 event. And then the contract down the line between the last midstream and the downstream has a force majeure clause that is not back-to-back. So when we have this type of asymmetry between clauses, the loss is going to lie in a different place than we would perhaps expect it to lie. So in this example, it will lie with the midstreamer. Similarly, the situation may be different if you have a long-term contract. So when you're looking at the period for performance, you need to look at what the nature of the commitments is. When should those commitments be performed? For an example, if you have a volume contract that requires a certain volume to be shipped over a period of 2 years, then the effect of COVID-19 as a force majeure event might be different than if you have one contract for one shipment of goods. The time of the interruption, the length of the interruption is important. The question at the bottom of the slide is how long is long? And we can't answer that at the moment because the situation is developing and it will be very fact specific. But we can come back to the Hong Kong tenancy decision in the case that dealt with SARS, where they looked at a 10-day lockout from a building in the context of a 2-year fixed term lease was not sufficient to frustrate that contract.
Thanks, Liz. One of the important things that I think has been highlighted as we've gone through this is that the particular jurisdiction and applicable law to the contract is going to be important. We've got the common law on the one hand and civil law jurisdictions on the other. And where you've got a chain of contracts or a number of contracts with different governing laws, this will give rise to a conflict. And it's not always within the parties' control which law will apply. In that sense, I mean that sometimes when you have onshore contracts, parties' bargaining positions at the beginning of the relationship may be difficult. And concessions may be made and different applicable laws may be adopted in order to get the deal done. Well, does that matter? Well, in some senses, yes, and in some senses, no. And we've put up here a question about enforcement. where you have a judgment of a court, say a Hong Kong court or an English court, the question is, can it be enforced in the place where there are assets? Well, if the assets are in mainland China, the question is only if there is a treaty allowing reciprocal enforcement of judgments. The question when it comes to arbitration awards is slightly simpler because there is an international convention called the New York Convention, which allows parties to enforce an award in any convention state. That means any state that has signed up to the New York Convention. Great, I hear you say. But here we have a question that is unresolved. So we've seen already that the Chinese government has issued excuse certificates in relation to force majeure, and they clearly consider that the COVID-19 is an unforeseeable event, giving rise to all sorts of problems. However, we've also seen that under common law systems, that analysis may not be the same. Thus, you may get a situation where an arbitration award, which on its face appears completely enforceable, is made by an English Hong Kong tribunal stating that this event is not force majeure and that the Chinese party is required to pay damages. And you take that to the Chinese court in order to enforce, only to be told that, oh, actually, in China, we consider this to be a force majeure event. And therefore, on the grounds of public policy, we're not going to enforce your foreign arbitration award. Now, although that is a risk, we consider that risk may be quite small and mitigated by the current practice of Chinese courts to enforce foreign arbitration awards. However, it's an interesting space to watch. Liz is also going to now deal with what happens if COVID-19 is not force majeure.
We've already had change of law clauses mentioned, which is another possibility if you don't come within a force majeure clause. You could also look at a material adverse change clause, particularly in a finance type agreement, if that was what you were dealing with. But the most important alternative, certainly from an English and Hong Kong law perspective, is going to be the doctrine of frustration. Force majeure we've talked about as a creature of contract, whereas frustration is a standalone legal concept under English and Hong Kong law. Force majeure will usually suspend performance, but frustration will allow the contract to be discharged. So we're talking here about when something occurs to make it physically impossible or commercially impossible to perform the contract, or some kind of event that transforms the contract into something very radically different than what the parties anticipated. The bar to make out a case in frustration of contract is very high, and certainly with COVID-19, I don't think we are there yet. The requirements are that the frustrating event must not be provided for in the contract itself. It must not be caused by the parties seeking to rely on it. And it must be an outside event or something extraneous, some kind of extraneous change in the circumstances or situation. So again, we are going to come back to the length and intensity of the event itself. And the case that's quite often cited is a case from the 1980s, which is a House of Lords decision called National Carriers and Panalpina. And in that case, there was a 10-year lease of a warehouse, and the city council closed the street that gave access to the warehouse for 1 year. It was the only way that the tenant could get access to this warehouse that it needed to use. It was a commercial lease. And the tenant refused to pay rent and argued that there was frustration of the contract. The House of Lords held that there was no frustration, even though the tenant wasn't going to be able to access the warehouse by the street for a year. And the court held that after the street reopened, there would still be 3 years left on the lease. And so therefore, the length and intensity of the event wasn't sufficient to frustrate the contract.
Thanks, Liz. We are running short on time, but we did promise to say a few things about shipping. What is the impact of COVID-19 on shipping? Just very, very briefly, it's quite unusual to find a force majeure clause in a shipping contract. However, exception clauses are quite normal, and there is a compulsory application of international convention called the Hague and the Hague-Visby rules in many circumstances, which may apply. And these rules also contain exemption clauses that will exempt carriers from loss or damage arising from very many force majeure-like provisions. In addition, there will be ability to excuse performance in relation to quarantine. Finally, there are in most shipping contracts obligations to sail between safe ports. The question will arise whether a port that is affected by coronavirus will be safe or not. But that question is answered quite shortly with whether the ship can go into the port, perform her duties and leave without danger. And arguably, at present at least, it would seem that it's difficult to say that a port will be unsafe. And the final question here is whether hire for the ship will be payable during the period of the COVID-19. Now, that is a question of fact and degree again, but the question to answer is, during the period of suspension, or during the period of COVID, is the vessel at the disposal of the charterers? Are the charterers able to use it? And if they are, then hire will be payable. We're going to skip over the concluding remarks, which you can read later, and move on to a look at the employment provisions. Jezamine.
Thank you, Andrew and Liz. As Andrew mentioned, I'm going to be talking about employers' obligations in respect of the COVID-19 outbreak. We will cover what employers should be doing, what requests they can make of their staff, and how to respond to any pushback which they receive from their staff. Can I go to the next slide, please? So in terms of looking at the employer's obligations, these main four ordinances set out what the employer's obligations are. The Occupational Safety and Health Ordinance requires that all employers, as far as reasonably practicable, ensure that the health and safety at work of all of their employees. Any breach by the employer to do so is a criminal offence and can result in a $200,000 fine being imposed on the employer if convicted. This is combined with the common law duty of care, which employers owe to employees to take reasonable care of their safety and provide and maintain a reasonably safe place of work for the employees. These two, the common law duty and the OSHO ordinance, have become quite topical, especially in respect of employers' duties to provide safety equipment such as surgical masks to its staff. We'll go on to speak about that a bit later. Most of you are aware that the employment ordinance provides a minimum level of protection for all employees in Hong Kong. So employers there are under certain obligations in respect of making payments to staff for salary, ensuring that staff are paid sick leave when the requirements are met, and also they allow the employers to dismiss staff when lawful and reasonable orders of the employer have not been followed. Combined with the employment ordinance, there's also the implied duties which apply to all employment contracts in Hong Kong. They're implied through common law, and one such duty would be the duty of mutual trust and confidence, whereby employers shouldn't take any steps which would jeopardize the employment relationship. Now, the disability discrimination ordinance will really only come into play in the event that an employer has employees who have been diagnosed with COVID-19. In that respect, the employer must ensure that they do not discriminate against any employees who have the disability, and COVID-19 would obviously amount to a disability within the definition section of the ordinance. Also, the employer will be under an obligation to ensure that any sufferers of COVID-19 are not harassed either by the employer or by any employees, and to protect them from any vilification. The Employees Compensation Ordinance is an interesting one. The Labour Department's recently issued a statement stating that although at present the COVID-19 is not recognised as an occupational disease, but they have reminded employers that basically if an employee was to contract COVID-19, they could make a claim under the Employees Compensation Ordinance where they've contracted a disease which amounts to a personal injury by accident arising out of and in the course of employment. Next slide, please. So what should employers be doing? Well, most employers should be having a contingency plan which they should be implementing. There is no legal obligation to have a contingency plan. However, by having one, the employer will be able to show to its employees that as far as is reasonably practicable, they've taken steps to ensure the health and safety of work of their employees, which is the obligation under the Occupational Safety and Health Ordinance. These plans have, for some employers, been in place since 2003 when we had the SARS outbreak. Some employers who didn't have a contingency plan at that date has had a slightly different contingency plan when dealing with the protests that have rocked Hong Kong for the last 8 months. So in terms of what this contingency plan is seeking to achieve, it's on the one hand looking at safeguarding employee welfare, and on the other hand, it's also seeking to ensure business continuity. Most plans are broken down into 3 steps: preventative measures to take before an outbreak. The second stage is triggering the plan during an outbreak, and the final stage is dealing with post-outbreak. Now, depending on the individual employers, some employers would consider that actually stage 2 of the plan is already in place because Hong Kong has a number of cases where employees have been infected with COVID and people have died from it. Other employers may take the view that actually stage 2 is not going to be triggered until one of our own employees contracts the disease, and that's when we will then trigger stage 2. Communication is very much key to any success of a contingency plan. The more detail in the plan, the better. Generally, it's very prudent when you have these plans to try and, as far as possible, do dry runs, because it's very difficult to foresee every possible step, and there will always be hiccups along the way. I think that the best plans are also very flexible, given that the situation in respect of COVID-19 is changing on a daily basis, and it requires employers to update some aspects of the plan, such as travel restrictions, as we see more and more countries that are being affected by clusters of people being diagnosed with the disease. Next slide, please. So in terms of having a good contingency plan, these are some of the things that you would expect to see in the plan. Looking at pre-outbreak, I think most of us know that in Hong Kong, it's very difficult to buy surgical masks at the moment, and that's something that's affecting the whole world. All suppliers of surgical masks are having issues in producing enough supply to keep up with demand. However, although you can't pop down to your closest pharmacy and buy masks off the shelf, it is still fairly easy to order masks from countries like Malaysia, who can arrange for deliveries within a couple of days. Now, in terms of the provision of masks, we've received lots of questions from employers who contact us and say, is it a must? Because there's no scientific proof that by wearing a mask, our employees won't contract the virus. And given that Beijing has announced that the virus is capable of aerosol transmission, then even if you wear a mask, you can still contract the virus through your eyes. I think most medical experts have actually come out to say that basically wearing a mask promotes good personal hygiene. It means that people that are wearing them touch their nose and the mouth a lot less. So even if it means that it won't stop you from contracting the virus, if you're already a carrier and you don't know it, it will assist in helping prevent you passing on the virus to others. So employers should really ensure that as part of the pre-outbreak plan, they are ensuring that they do have a supply of masks for people in the office. They should ensure that the masks are appropriate. They need to be 3-ply masks if they're the surgical masks. Generally, in terms of what's acceptable, the N95 standard masks are considered the appropriate masks that people should be wearing. Employers should remind their staff to practice good personal hygiene and to ensure that basically there is a good supply of soap and hand towels within the office so that people can wash and dry their hands properly. In terms of ensuring that if there's going to be an outbreak, employees that have the ability to work from home can do so. Employers should ensure that there is the correct software on employees' laptops and they will be able to connect to the systems. Employers need to be very clear to staff, not just in terms of what the different stages of the plan are, but what they expect of staff once the plan is implemented. If you have a great plan, but then you have management that send out mixed messages to staff, the staff are going to be confused, and this could potentially put them at risk. Employers should be clear if they're saying to staff, we want you to work from home, we don't want you to come into the office. If employers want to allow the employee to have some discretion in choosing whether they stay at home or come in, they should tell them that it's their choice, and also to make it clear that if it is their choice, then despite what their supervisors are telling them, it remains their choice. Employees that travel regularly for work need to be told what countries that they can continue traveling to, and as the number of outbreaks increase around the world, what countries will go on the list, which means that staff cannot travel there. Employers should also ensure that announcements are made frequently to staff to remind them what is practical. And if there's any issues, to seek feedback from staff. As I said earlier, what to do during an outbreak will very much depend on what employers consider the outbreak. Is it going to be only an outbreak in the office? If you expect staff to work from home, then the management should really lead by example. Staff generally will follow what management do, and if the management continues to come into the office, they should expect the staff to do the same. Employers also owe duties of care to their employees. So where there have been employees in the office that have been diagnosed with COVID-19, they should let other staff know, particularly if prior to this outbreak they've been in contact with other staff, so that they can make staff aware that basically some of their colleagues have been infected, and if they're suffering symptoms, they should go and seek medical help. Post outbreak, obviously there's a quarantine time for people that have been diagnosed with the virus to recover from it. A lot of employers, in terms of travel, are also asking employees to self-quarantine within 14 days. This was prior to the government's compulsory quarantine orders coming into effect. In recent news articles, there has been questions as to whether a 14-day quarantine time is sufficient, given that it's taken some people that have been infected with the virus 27 days to show symptoms and to test positively. Next slide, please. So in terms of the mandatory requirements, I think employers need to be quite flexible in deciding what's best to safeguard their staff, and really not just look at what the legal requirements are, but consider best practice and how the staff are likely to react if they were to impose measures that would prove unpopular. Obviously, Carrie Lam, after Chinese New Year, made an announcement in the news saying that she would be requiring all civil servants to work from home, and strongly recommended that the private sector follow suit. Now, in her latest broadcast about a week ago, she stated that the civil servants would continue to work from home up to the 1st of March, but made no comment as to what she was expecting of the private sector. So she really now is leaving it up to employers to decide. Given the duties on employers to safeguard the staff, employers should be very careful if they are asking their staff to come into the office as normal, and to take into account whether they have sufficient protective equipment in the office to safeguard their staff. Taking into account also the fact that the Education Department has now extended till the 20th of April, the closure of all schools and kindergartens, means that some staff with young children may not be able to attend the office on a daily basis. So employers really need to listen to their staff to ascertain what it is that they're comfortable working with. I think for the majority of office workers, they have the ability to work from home. It may not be as efficient as working from the office, but if staff have major concerns and have an inability to source face masks themselves so that they can do the commute from home to the office, combined with the fact that they may have young children at home, or they may be in a high risk group, they may not want to expose themselves to having that commute to work, on the basis that at the end of the working day they may have been infected with COVID-19 and be taking it home to the families. Obviously, the family discrimination ordinance is the family status ordinance is another anti-discrimination ordinance which employers need to consider when speaking with their employees regarding what their preferences are and what the needs are of their employees from the family side. Next slide, please. So in terms of the legal requirements, for all Hong Kong residents, there is a 14-day mandatory quarantine, which they will have to undertake if they arrive from China, or as from yesterday, from South Korea. Now, if employees are returning from business travel, then obviously the employers will have some sympathy with them having to go into mandatory quarantine. Mandatory quarantine can mean that the employees either have to stay at home for the 14 days or they go to a quarantine camp. Whilst they are in quarantine and under the compulsory mandatory order, they will be provided with a sick note certificate. Therefore, employers cannot terminate the employment of their employees whilst they're under mandatory quarantine. Now, where you've got employees that are still going over the border either at the weekend or for annual leave, this can be a problem for employers. Employers can't tell their staff what they can do in their free time. They can only encourage their staff not to go to these affected places. So that is something that really needs to be considered in terms of how employers deal with employees that voluntarily expose themselves to being put into a 14-day mandatory quarantine period. If there are employees that go over the border on the weekend, come back and then inform their employers they are in mandatory quarantine, whether the employer can say, are you able to work remotely for the 14 days so you continue in normal employment? If you're not, then potentially you will need to be dealt with as if you are on sick leave. In terms of dealing with staff who are diagnosed with COVID-19, the employers have to pay them sick leave pay where they've accrued enough sick leave days. Those staff that say that they've contracted the virus from work may then make a claim under the EOC, and their employer will then have to inform the Labour Department. The employer also needs to ensure that where their own employees have been diagnosed with COVID-19, that they make the necessary communications, not just to their own employees, but potentially also to any visitors to their premises. Under the Occupiers Liability Ordinance in Hong Kong, the owners of premises do own certain duties of care to anyone visiting the premises. And so where you've got clients coming into the office or suppliers coming in to deliver supplies, you should make them aware in the event that there has been an outbreak of COVID-19 there. Also, for most employers, they will need to then take steps to close down the office if there's been an outbreak where people have attended the office, and to ensure that it's thoroughly disinfected. Now, under Hong Kong law, there is no obligation to allow staff to work from home. I think for forward-looking employers, they will already have work from home policies in place. Employers should, when deciding whether to allow staff to work from home, consider the impact of the decisions that they're going to make. If they have staff that really want to work from home and they tell them that they can't, it's very likely that staff could potentially call in sick, and then you go from having a reduced amount of productivity to potentially very little productivity. Where you have employees that tell their employer that actually I have a long-term underlying illness, therefore if I contract COVID-19, it's going to very much adversely affect me more than any other employee that doesn't have an illness, then really the employers should listen to these staff. And we're not talking very serious illnesses here. The 2 Hong Kong residents that have died from COVID-19 both had diabetes, which generally isn't a life-threatening disease. However, because COVID-19 is so new and clearly affects those more severely with an underlying health issue, it is something that needs to be taken into account. For employers that tell their staff, we want to know your travel history, we want to ensure that if you're going to come into the office, you haven't been anywhere which has had outbreaks of the virus, there is no legal requirement for the employees to comply with providing the travel history. The Personal Data Privacy Ordinance will then kick in once employers request this information. So if employers want to do this to make sure that employees within the office are safe, they need to comply with the provisions of the PDPO and make sure that they actually tell the staff why they're asking for this information, what's going to be done with this information, how long it's going to be retained for. And similarly, this applies to asking employees if they've been diagnosed with COVID-19. It's obviously reasonable for employers to ask for this information, but again, from the standpoint of an employee, they could choose not to cooperate with the employers in this respect, and therefore the provision of this information is voluntary. Next slide, please. So in terms of practical considerations, there's the majority of employers that are allowing staff to work remotely. We've had questions raised to us from employers saying that staff have gone and started working remotely out of Hong Kong, and whether they should accept this or can they insist that the employee works within Hong Kong. Obviously, this is more of an issue where there's a time zone difference. And what our advice is to employers is, if employees have the ability to work remotely, then they can work remotely within Hong Kong or outside of Hong Kong. Obviously, where they're client facing or they need to liaise with colleagues within Hong Kong, they should, as far as possible, try and work on the Hong Kong time zone. Again, the issue of working out of Hong Kong may trigger tax consequences to employees in the event that they are staying overseas for a long period of time, which may result in them becoming a tax resident elsewhere. But that is something that the employee will need to deal with. in terms of employers that have had shortfalls in terms of work, where their work's been very much impacted by COVID-19, they've asked us, can they insist on staff taking unpaid leave? Unpaid leave and the reduction of hours isn't something that's basically covered by the employment ordinance. This would have to be mutually agreed with employees. Generally, I think so long as the message is delivered in the right way to employees that the business is suffering and therefore there are now financial constraints on the company, most staff will accept that they may need to take unpaid leave, and in the event that they choose not to, there is the possibility that they could be made redundant. So employers should keep an eye on the Labour Department in terms of what they're saying regarding employees' compensation, and if there's going to be a change regarding COVID-19 being regarded as a occupational disease. For all staff that travel, they need to update their lists regularly. I think overnight we've seen an explosion of COVID-19 cases in Italy and Iran, as well as South Korea. So the policy needs to be constantly evolving. I think most of the other issues that are mentioned on this slide I've dealt with. So I'm going to leave it there and hand back to Rahul, and then take any questions.
Sure. Thank you so much, Jezamine. I think we are out of time at the moment. So what we would like to do is I'll just turn the webcam on so all the attendees can now see you. Just give me 1 second. There we go. Great. So thank you so much, Andrew. Thank you, Jezamine, and thank you, Elizabeth. Great. This was terrific. The video of this webinar will be available later on, and you'll get an email from us with the email IDs of all the presenters, as well as the link to the video of this webinar. We had some questions. We tried to answer these questions on the chat. All the attendees must have seen it. Some of these questions were already being answered in the presentation. However, if you have any further questions, please feel free to get in touch with either Andrew, Elizabeth, or Jezamine directly. Their email IDs are on the next slide. If Andrew, you can change the next slide, all the email IDs I think are on the, yeah, there we go. All the email IDs and contact details are there. After this webinar, when we close this, there will be a very short survey which we will need for all the attendees to fill. There will be one CPD point that has been applied for, so filling the survey would be crucial to that CPD point. Well, with that, thank you very much for attending, and thank you to Stephenson Harwood for co-hosting this webinar with us. We look forward to having you at our next webinar, and have a great day ahead. Thank you very much.
Thank you.
Thank you. Cheers. Bye.
Bye.